Hi, everyone. Harry here to talk about another very hard-hitting order against the Trump administration and just going directly in response to the crazy and nasty comments by the President of the United States. We're talking now about the shutdown and his virtually crowing. This has given me all this outsized power to do what? Screw Democrats. It's really out there that he can now kind of arbitrarily fire people from agencies that have greater Democratic representation in their employees and take away all these funds that go to programs that are good for Democrats, both in policy and politically. So this has been the Trump Make My Day program where he's really been right out there. And he said yesterday, well, it's only fair because they started it all, a very dubious characterization of the facts. But anyway, the AFL-CIO sued in the Northern District of California, and Judge Susan Ilston entered a very strong preliminary injunction yesterday saying, oh, no, you don't. No more layoffs, or just halt the things you're doing. No layoffs, no rifts, etc. during the shutdown. They are, for one, the FLCA had come in and just shown what a total bedlam, chaos, Keystone Cop show the whole thing is. No surprise, because you have a legal kind of template for how you're supposed to handle shutdowns, and then the bull in the china shop administration comes in and says, forget that, or on top of that, or emphasizing go after Democrats. So besides the patent viewpoint discrimination, it's just a bloody mess. And so the AFL-CIO brings up all in their complaint the total lack of planning and process, but also just says this is not how it works during a shutdown, and Judge Ilston agrees. So she enters a very detailed preliminary injunction. Remember this issue about people who win having to post a bond, and so she sets a bond of $10 total, not for plaintiffs, so a nominal bond to just satisfy the law, so they can't say on appeal. She didn't even make them set a bond, and then sets a briefing schedule to actually consider the motion for a preliminary injunction. Moves pretty quickly. The first brief is due in less than a week. Okay, along the way, the judges are getting bolder and bolder, but she basically takes the administration to task and just says, this is so abnormal. And the way we do things in this country is by law, not fiat, not an executive strongman just stepping into a vacuum and using the power to just screw the other party. That's just not how it works. You need laws here. And by the way, most of what he's doing is Congress's lookout. The same thing we're seeing in case after case, and just district court, especially judges, being increasingly emboldened to call out what is happening. The actual holding here, what is the problem that she uses in order to enter a temporary injunction is a violation of the Administrative Procedures Act. Judge Ilston says the core issue here, they're likely to prevail under the merits. This is the plaintiffs, because if what plaintiffs allege is true, and you often do that at the pleading stage, then the agency's actions in laying off thousands of public employees during a government shutdown and in targeting for reduction in forces, RIS, which are supposed to be carried out very methodically and fairly according to law, etc., and in targeting for RIS those programs that are perceived as favored by a particular political party is the epitome of hasty, arbitrary, and capricious decision-making. The many snafus that plaintiffs detail in their papers are further testament to this. So those all go into the basic hopper as showing they're a complete mess, and it's both arbitrary and capricious the way they're doing it, but the basic idea of let's figure out how to screw Democrats, that too is arbitrary and capricious. Now, the plaintiffs, the union actually raised a number of claims about acting ultra vires out of their authority and about specific constitutional violations because, going after Democrats and not Republicans. Ilston puts it on the footing of you guys are just, complete mess. And more than a mess, you are doing something, it's pretty charged language, doesn't quite say that's un-American, but pretty darn close. Statements like, we do things according to laws in this country, not caprice. And that holds for shutdowns as well when there are laws and procedures. So this tough talk that Trump has had in the political sphere to say, make my day, I'm going to make you rue your decision, Democrats, to not cave and not capitulate to us and actually have a shutdown because of the Democrats' a few desires, but the main thing going on has to do with extension of Obamacare subsidies. And he's saying if you don't roll here, we're going to really take all the skin out of your hide. And actually, to date, the Democrats have said, okay, I think they perceive they are winning the shutdown, and the Republicans are kind of scrambling backwards. But in any event, the notion that they have to be put to the choice of either advocating for their policies, the healthcare, or having all kinds of programs that especially favor their constituents just, ripped away arbitrarily. That is what the judge is saying is dirty pool. So arbitrary, capricious as the day is long, temporary injunction in place, quick for consideration of whether to do a longer injunction. That's where it stands. Now they'll move pretty quickly to actually litigate whether an injunction should be put down unless the administration does its favored maneuver of running up to the Ninth Circuit and say, emergency, you must let the president do all this nasty stuff that disproportionately harms Democrats and is designed to do so. It's a reparable injury that you don't. And we'll see how an argument like that might play in the Ninth Circuit. As of now, linebackers are frozen and Trump can't do his nasty shutdown governance of particularly screwing Democrats. And they'll move on to litigate that. Of course, the shutdown seems to be holding and they don't seem to be really making a lot of progress, but just history being any guide and the damages that it's occasioning, you can't imagine it goes on that much longer. And this case itself, his hands could be stayed until such time as that really the shutdown is over. So now's a unusual litigation setting where time may well be on the side of the challengers to the administration rather than Trump, who is spoiling to just punish Democrats in the shutdown, but as of this morning anyway, is forbidden by law from doing it by a very strong, rhetorically and legally, order from Judge Susan Elston. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.